So, shall now call Verena Steller, a researcher at Goethe University in Frankfurt, Germany, where she has also been a member of the interdisciplinary cluster of excellence on the formation of normative orders. Her research focuses on legal history, imperial history, international relations, and the cultural history of diplomacy. This one?
Thank you very much for the kind introduction, and thank you to the organizing committee for this wonderful conference. So perhaps the story I'm going to tell is not so very different from the one we just heard. So, quote, "A mockery of justice and of the rule of law, a procedure repugnant to civilized methods and principles of British justice." That is how the first practicing native Indian barrister, Manmohan Ghosh, commented on the high treason trial against the Manipur princes before a special military tribunal in 1891. After a palace revolution in Manipur, the British chief commissioner had tried to arrest the leading general of the Manipur army. In the subsequent fight, the chief commissioner and 4 of his officers had been killed as they were taken prisoners, beheaded, and their bodies mutilated. The regent of Manipur and a senior general, who had apparently ordered the execution of the British officers, were put to trial before a special military tribunal. Although Manipur was one of the rather small 600 princely states, its strategic geographical position connecting Assam and North Burma put it on top of the political agenda of both houses of parliament. So at Westminster, the events of the summer of 1891 were soon well known as the Manipur disaster, and it was hotly debated whether it was a family affair or a political revolution, an open mutiny, and an act of rebellion against the state. "The state of Manipur is one practically of our own creation," Member of Parliament Curzon told the Commons in June 1891. "A state maintained by 8 British interventions between 1826 and 1866, Curzon said, "occasion on which the British Indian government have interfered to protect the ruler of Manipur against those who rose up against him and against the paramount power, that is, us. Manipur is not an independent state, it is a protected state subordinate to the British Crown," Curzon said. The process the Manipur princes had to face was thus a state trial on the charge of waging war against the Queen for disloyalty to the Crown. In India, Section 125 of the Indian Penal Code of 1860 defined high treason as armed resistance justified on political principles to the established law of the land. Now, my argument is that it was to a considerable extent the first generation of Indian barristers who entered the courtrooms of the Indian Empire in the late 1860s and set out to confront the rule of law with its inherent paradoxes in the formative years of the Indian nationalist movement born between 1870 and 1890. The cases on which these Indian barristers worked presented starting and leverage points for critique of colonial rule in 2 fora of justification, the public and the courtroom. This was especially true for this very prominent category of state trials dealing with offenses against the imperial and colonial state, in which the validity of the English law and its principles, as well as the promises of the rule of law, were tested in India. My contribution seeks to highlight one of these cases. The legal and political status of the princely states was far from evident. The cases of the Manipur princes was at the intersection of imperial legal administration, forms of governmentality, and the jurisprudence of imperial constitutional law, as Lauren Benton calls it. In fact, the barrister Ghosh, the government of India, and jurists of international law had to deal with a deep theoretical puzzle of Indian states, of how to understand the relation of law within polities to law between or across polities, that is, law in its multiple forms of transition. Between the 15th and the 18th century, European and Indian states had maintained diplomatic relations based on contracts, reciprocity, and mutually agreed principles of interstate dealings profitable for both. These diplomatic treaties were even part of European compilations of international law. In contrast, in the 19th century, the British experimented with various political arrangements, forms of contract, rights, and obligations. Thus, the acquisition of territory could be effected by cession, occupation, accession, subjugation, or prescription, and result in protectorates, protected states, crown colonies, dominions, leased territories, condominions, suzerainities, and as a consequence, concepts of internal and external sovereignty multiplied. Forms of indirect rule, subsidiary alliances, partial membership, and quasi or semi-sovereignty coexisted. Soon the empire had to deal with a variety of subordination relations, oftentimes with tremendous contradictions in the use of legal arguments and instruments. In the case of the Manipur princes, questions of sovereignty, equality, reciprocity, recognition, and the obligation of the political partners arose. What did the Manipur princes owe to the British sovereign, and to which extent? The lack of coherent definitions, the openness of definition, would lead to a remarkable need for justification of the colonial state. As the British government had denied Gosch's application for a High Court appeal, he had only the opportunity to submit the written statement in defense of the Manipur princes, then widely published in India. In this memorandum of arguments, which he continued to call an appeal, Gosch criticized the trial as a mockery of justice. Because of the statutes according to international law, Gosch argued, quote, the Manipur princes were not and could not have been tried under the Indian Penal Code or any other British law. Nor was the court, he continued, which tried them, constituted under any legal authority derivable from any act of Parliament or any legislative enactment of the Governor-General in Council. I must therefore take it that in creating the special tribunal at Manipur, the government of India was simply exercising the right of a conquering sovereign power. End of quote. Gosch then referred to traditional English liberties to outline the various violations of the rule of law during the process. That is, a charge of high treason would have to be judged by a high court, not a special military tribunal. The Manipur princes were deprived of the right to be defended by counsel, an advantage, quote, which is enjoyed by every subject of Her Majesty throughout her dominions, and that is, that no man should be condemned unheard, has always been one of the cardinal principles of British justice. The special court was composed of 2 military officers and 1 political officer without any legal training, and judging from the methods of procedure adopted during the trials, it seems clear that the court as a whole was far from being familiar with the procedure followed during criminal trials in British India or in any part of Her Majesty's dominions. In addition, each of the accused persons had been subjected to an inquisitorial examination, a procedure utterly repugnant to the humane traditions of British justice, and which, had it been adopted by a judge or magistrate in British India, would have called forth severe censure from the High Court to which he might be subject. Neither fairness nor a public process following civilized principles and methods, in short, the rule of law, were guaranteed, Gosch thought. In the end, he expressed his hope, quote, that the government of India will hold the scales of justice evenly, and that, no matter how grave the crisis and how strongly national passions may have been aroused, British justice will always assert itself and take care to distinguish the innocent from the guilty. Now, Gosch's memorandum is of utmost interest for the history of rule of law in India, and that, I think, for 3 reasons mainly. First, because it was a kind of showpiece of intertextual references and a kind of management of legal pluralism. That is, because of its references to English common law, the ancient constitution reasoning, pillars such as Vattel, Hale, Colt, Blackstone, various handbooks on international law, cases of the Court of Admiralty, and English and Indian precedents. So this was a nice piece of work of legal pluralism with its colliding norms and languages. For example, when Gosch made out translation errors in one of the testimonies, in which a, quote, misunderstanding in the original became a mutiny in the English translation. Gosch's memorandum then was amazing, secondly, in proving the failures of the colonial mission of the validity of the rule of law. Gosch substantiates in an impressive list of procedural errors of the special military tribunal which the government of India would have to admit, even if only in their internal communication. And Ghosh's memorandum was a amazing third, I think, for the position it took on a highly controversial issue and the questions it provoked. The most vital one was, does Manipur owe allegiance as implied in the offence of treason? Ghosh summarized the debate on the status of the princely states, their relation to the crown, the validity of English law, and the jurisdiction of the courts. And then he discussed whether the princes in alliance with the British crown also owed allegiance to the crown, and whether this breach of this obligation was justiciable as high treason by section 125 of the Indian Penal Code as waging war against the Queen. In a nutshell, he would argue, Manipur had never officially been conquered. Therefore, by standards of international law, it was to be considered as a sovereign state. A justiciable duty of allegiance did not exist. To specify the status of sovereignty of princely states and to define a British legal policy towards them became one of the major concerns of administrators of the government of India and leading jurists of international law between 1870 and 1900. So you have a range of gentlemen who was occupied with the problem. And Manipur went down in history as one of the leading cases. And the initial problem was how to define the status of the princely states on basis of either international law or imperial policy. Mortimer Durand and Alexander Miller took the lead in their comments on Ghosh's memorandum and the internal communication of the government of India. Quote, the exact nature of the relation of the paramount power to subordinate states has never yet been defined, and it would be inconvenient, and I think it's unnecessary, to consider the extent or limit of our authority in such matters. Lee Warner concurred with the opinion that the extent of the British paramount power has been, quote, wisely left undefined, and the subordination of native states understood and not explained. Instead of fixing definitions, Lee Warner opted for a policy of indeterminacy, a flexibility which had earlier also been propagated by Henry Miller in an explicit theory of sovereignty, which you probably know. So he had stated that sovereignty has always been regarded as divisible. And with this concept of divisible sovereignty, he had countered the Austinian theory of command and opened up a considerable scope of executive action in the colonial context. For if sovereignty was divisible, the British have a scope of range of legitimate policy options in the empire. Westlake, whom you might know as the liberal founder of modern international law, was not a big help in strengthening the status of the princely states, and so Tupper's opinion prevailed that there are no independent states within the protectorates, so the relations between the state and the paramount are not diplomatic but political. He thought Manipur was a platform for a declaration of important principles on the subject of political relations in the case of a rebellion against the lawful order. And Lee Warner made out four of such principles, which you see here. And it was Tupper who promoted principle number 3, which he called a double allegiance standard. If sovereignty then is divided, the obedience must be divided and in like proportion. Correlative with the legal duty of allegiance on the part of the subject is the moral duty of protection on the part of the sovereign. And now for Tupper, this doctrine was the basis of a new system of political relations, substituting the older notions of Berg's trusteeship. To the rules and principles which constitute the new system, I shall, he said, throughout this treatise give the name of Indian political law, and that in another passage of the text he calls it the rule of political law. So in the end, Ghosh's appeal was dismissed, one of the death penalties was transformed in lifelong deportation, but Tupper's rule of political law seemed to carry off the victory over Ghosh's claim on validity of the rule of law. So, love's labor lost? Not quite, I think, because the memorandum was used as a platform too, by Ghosh, for a surprisingly successful opening up of a new form of justification and scope of action. And that, I think, is the fourth reason why this memorandum is so interesting for a story of the rule of law in India. That is, even if the government of India had already dismissed the application for a formal appeal process, he continued to call his memorandum an appeal in a form of his mockery of justice in a trial which was no trial by legal standards at all. And it was also his demonstration that the justice the colonial administration sought to render was was a mockery. And that's why Goethe took a strong positioning against the tendency that if British imperial laws were in force in a given native state, they now derived their standing as law not from the legislative or even judicial, but above all from the executive authority. So you see that in two of his positions and the reactions of Miller and Durand of the official side. No British subject, they said, has a right to an appeal as a prerogative of mercy. And they said, and in no case, so far as we are aware, has the sovereign or the Secretary of State on her behalf ever in the history of England heard counsel on such a question. Now, there's always a first time for everything. And you see that if you confer now Tappes comments, he assumes a footing of equality and creates a sort of in-between moment, a moment in which he claims the opening up of a new forum of justification and a forum which would prove essential to the constitutionalism of the Indian independence movement. Thank you.